आपने check कर लिया?
Yes, please.
My lord, I filed one PIL, my lord.
Mm.
This may be listed tomorrow, my lord,
Why tomorrow?
because urgency is there because illegal construction is going on. And this is against illegal construction.
Why a PIN?
PIL, my lord, initially I filed a writ petition, but the honorable court, my lord, had observed that since the matter relates to the issue involved is regarding my public interest, my lord. So I have withdrawn it with the liberty to refile as a PI.
You are against the construction.
Yes,
What
my
is the urgency? Have it on Monday. Monday is only. Monday is just. Monday reopening.
Monday, my lord,
First.
first.
May it please the Lordship.
Yes.
With the consent of other side, I beg to mention item number 6 to 33, Lordship.
Lordship, it's a joint prayer, Lordship. The matter, it's a series of matter where legality and validity of Assam anti-tax.
Item?
6 to 36, 5, Lordship, my senior colleague, friend is appealing.
Item number 5 is also in the same list,
Yes.
same batch.
So
Pertains to Arunachal.
item 5 to 33.
33.
No, not 33.
36, Lordship.
36. When do you want it?
Lordship, can it be taken up on any date after 24th of April?
On request made by the parties. Reach the matter on, when do you want? After 24th,
Yes, ma'am.
29th April.
Can it be any other date, madam? Can it be first or 2nd of May?
Doesn't matter. First, second.
Yes. All right.
My lord, item number 37.
Yes.
My lord, we are withdrawing from this case because of non-cooperation of the respondent assessee.
Have you informed them?
We have informed them. I have written them 4 letters. There is no response. We have tried to contact them over phone. There is no response.
You have already informed, isn't it?
We have informed the party.
Mr.
R. Goenka.
R. Goenka, Learned Council, for the respondents office, that they are withdrawing from what to call this? Withdrawing the Vaklatama
Yes.
in respect of the respondents. Stop. In that view of the matter, registry is directed to inform the respondents. Stop, list the matter after 2 weeks or 3 weeks.
So my opinion go the appellant.
Mr. SCKL, Leonard. CGC, isn't it?
Lordship Standing Council Income Tax.
Then a senior standing council income tax appears for the applicant.
The registry may be directed not to show our name in the list.
Okay, registry is also directed to delete the name of Mr. R. Goenka.
Yes, my lord. R. Goenka, UK Bhattakur, and A. Goenka. The 3 are there.
R. Goenka and his associates
Yes.
from the cost list. Registry is also directed to give a report with regard to the issuance of notice to the respondents.
Much. Me pleasure, Lordship. Lordship, I beg to mention item number 40, my lord.
Yes.
My lord, my senior is Anuel and he is now bedridden, my lord.
Who's your senior?
And Islam, my lord.
And Islam.
My lord.
So what do you want? What do you want?
What is your prayer?
My lord, adjournment for
For how many days?
2 weeks, my lord.
On request made on behalf of Mr. N. Islam, Leonard Counsel for the appellants, this the matter after 2 weeks. Yeah, yes,
May please, your lordship.
yes, please.
Your lordship, I beg to trouble your lordship over item number 43 and 44.
40,
43 and 44, your lordship, that tag matters.
yes.
I'm being led by Mr. M.K. Chaudhary, your lordship.
Hmm.
Need some accommodation for today. In fact, after 2 weeks, if your lordship fixes for a date subject to your lordship's convenience.
Have we taken the consent? of
Yes,
the-
your lordship. Yes, Mr. Bordpujari, you've taken the consent of Mr. Bordpujari.
And how about the petitioner's counsel in the other?
In fact, the brief has been handed over to Mr. M.K. Chaudhary, your lordship.
Both.
Yes.
Okay,
the
on
Ahmed
request
is-
made on behalf of Mr. M. K. Chowdhury, Leonard Senior Counsel for the petitioners in WBC 4338 of 2019. List the matter after.
I'll leave it to your lordship's convenience for a date.
It's up to you.
Since
We
you
can have it tomorrow.
After 2 weeks, your lordship.
After 2 weeks.
I'm grateful. Your lordship.
Yeah.
May I please, Lordship?
43 and 44. Yes,
May I please, Lordship? Lordship, I beg to mention for listing up of 508 of 2018. Lordship, the matter is for hearing.
read appeal.
Read petition, Lordship. Read petition.
Writ petition before a division bench, what kind of writ petition?
The matter is for promotion, relating to promotion.
Writ petition,
Is it the single bench matter or the division bench matter?
Lordship.
You
Sorry,
verify, you verify. I think it's a single bench.
Obliged.
Item 1 of daily list order.
Oh,
My lord, may I kindly peruse.
last occasion, my lord.
what is this?
Last occasion, lordship directed us to furnish the, my lord, information whatever we had, my lord. And accordingly, we have furnished all the documents what we have, my lord, Kala,
1 minute.
last occasion, my lord. Last order.
12:3. Yes.
Regarding valuation and my lord, measurement of the particular house, my lord. According, we have directed, my lord, to furnish all the instruction, my lord, information, my lord. Whatever on that date, my lord, the statement was not correct, my lord. We have already furnished all the documents, my lord, and which has been annexed in the REIT appeal also, my
You
lord.
are paying for Kala.
Kala, my lord.
You have for the.
I'm for the NHI resale, my lord.
And the documents, my lord, subsequently also, we sent a letter to the NICDCL and furnished all the documents, my lord, what we have, my lord. And under, my lord, section 3A of the National Highway Act, my lord, after publication notification under section 3D, land has already vested to the central government. And whatever the amount, my lord, Zirat and land compensation, we have, Kala has already paid to the, my lord, REIT petitioner, my lord. That is my instruction, my lord.
So, my lord, my application is on different footing, my lord. My contention is that whatever it may be, what outcome of the arbitration proceedings, my lord, let us, my lord, let the NHIDCL, my lord, proceed with the work, my lord. Because, my lord, we have been suffering from last April 1923. So, my lord, there was a direction by this honorable court to conduct a measurement exercise and submit a valuation report to the CPWD. Now CPWD communicates back, says we have done a measurement. In fact, we are also present, a joint measurement was taken. But to evaluate, my lord, the evaluation, to prepare the report thereof, my lord, some certain queries were made to the Kala. So they have answered, my lord, it's now it's between the CPWD and the Kala. My lord, pending this, my lords, let the arbitrator also take a call. Let us proceed with the work, my lord, because monsoon have now set in, my lords. And one major issue has come up now. Due to this stay order, my lord, service road, which is normally used by the normal citizens, my lord, pending the highway construction, that is also being stopped, my lords. The people are also suffering and public safety is also compromised, my lords. My application has 2 parts, my lords. That modification, my lord, I'm not seeking now. I'm just pressing the leave to proceed with the work, my lords.
Yes.
Have you received the compensation?
My lord, a part of the same has been received, my lord. But they are. Paid to us.
But that is the subject matter of arbitration, whether compensation is adequate or not. But will that be an impediment for proceeding with the work?
My submission is that, the order of the Supreme Court is very much clear, they have to measure and they have to give the report, already measurement has been done, Some information regarding, at page 50, which is mentioned, the year of construction, some of the information that is required by the CPWD from the Kala to come out with the.
These are formalities which should be over within
7 days, my lord. Now,
but the work, public interest is at stake.
I'm concerned on that also.
So how are you being benefited by stopping a work of so?
That's what against the work, you want to work.
Let
with
the
the
work proceed and we'll direct them to expedite with the directions of the source of completing the measurement and finalizing the matters.
But these aspects of the matter already taken care of, in the earlier round, in the.
No, now how are you benefiting by stopping the work? Tell us.
My only submission.
How are you benefiting?
No, I'm not.
If you are not benefiting, then why are you stopping the work?
No, my lord, once they will start the work, my lord, they have not done, my lord, but.
You have said on your own, but that measurement has been done, some years are to be verified.
Yes.
In fact, my lord, I have a comparative statement of the both the measurements, my lord.
Several rounds, my lord, they have not been big, my lord. But, my lord, now the Kala has been submitted, that information has been provided, but according to him, no information has been provided, my lord. So, anything will be
My lord,
saved, my lord.
my lord, that is the there, my lord. And lordship may direct, my lord.
Mr. Alama's statement has been made in the bar by Mr. Supriya, that the measurement has been done. You are more or less agreeing with the statement. You are only saying that some more details has to come. He is making an undertaking that within 7 days it will be given. And if there is any dispute still pending, it will be decided by arbitrator.
And
There's a
lordship,
mechanism for addressing.
lordship may direct a particular date fixing, my lord, Kala, NHIDCL, read petition and CPW. All of them will present within 7 days in the site, my lord. And whatever the documents required, all the documents will be furnished on that day if no documents are there, any clarification. And the construction is going on. If you lordship look into the last page of my instruction, they have, my lord, read petitioner after, my lord, payment of compensation, they have constructed, my lord, again, my lord.
On one particular day. And then.
In fact, my lord, they seek a compensation of 80 lakhs. 60 lakhs has been paid to them.
My lord, any date lordship may direct, my lord, to present on the site itself,
Mr. Alam,
Yes, my lord, I agree on that, my lord.
on the site itself, my lord.
Relation report will be funded on that day, my lord.
Yeah.
There, my lord, two other parts are there. On the one, my lord, lordship may look into our instruction. They have, after, my lord, demolishing the house, my lord, they have reconstructed it, my lord. So the valuation, they will take, all the persons should be present and they will take care of it, my lord, on the date of construction regarding that. Earlier, my lord, as per section 30 of the, my lord, 2013 Act, competent engineer is required to make the measurement. Assam CWD make the measurement, my lord. Now the division bench passed the order, my lord, this honorable court, by CPWD, my lord. But now the point arises, my lord, some clarification against the order of CPWD, my lord, appeal lies under section 34 to the High Court. If the division, if this honorable court pass an order to direct the CPWD to make the measurement and it is required to be accepted by the arbitrator, then, my lord, that it will be affect other ways also, my lord, to the parties.
Mr. Kutia, we are not going to the marriage. We
My
are
lord.
only trying to consider the application of Mr. Gupta.
My lord, my lord, my lord.
By which he also making a concession that right now he'll be more interested in
Construction, my lord.
direction for going ahead with the construction.
My lords, that's what.
Because that part is directly connected with immense public
My
interest.
lord, my lord.
But Mr. Alam is saying that the measurement has not been done.
No,
Measurement done, my lord, report not submitted.
Incorrect.
Measurement has been taken. He has submitted.
Incorrect statement, my lord, it is.
I'm submitting, but
No, you are
the valuation, my submission is but very measurement.
My lord,
has been
it is,
done, but-
my lord, my lord, he has filed a read appeal, my lord. He has filed a read appeal and it is in the annexure 1 of the read
Even
appeal.
the evaluation report.
Annexure 1 of the read appeal, my
There
lord.
is a clear direction somewhere.
My lord, it is annexure 1 of the read appeal, my lord. Annexure 1.
43, my lord.
Of
Page 20 of the IA, my lord.
Now, read appeal also there, my lord.
The order of the Honorable Court, my lord.
the order, okay, but where is the?
Page 43, my lord.
No, that we have said.
Read appeal, my lord, annexure 1.
That means
Page, annexure 1.
Annexure 1, my lord.
page. Page,
Page 121, my lord. Which was duly received by NICDCL also. Signature of general manager is also there.
1 to 1.
121.
Here, isn't it?
Edit page also. That is Assam PWD made the valuation, my lord. Measurement and valuation, my lord.
আমি ললো এইটো। Joint এটা লৈ গৈছো।
Then, my lord, page 161, what is the contention of the repetition, my lord? Their valuation, my lord.
Page
Page 161, what the petitioner submitted, my lord, the valuation of his own, my lord.
121 is the assessment of so-and-so.
Uh,
That is Kacha structure, garage, all this.
all these things, my lord. In the next page, 122, signature of executive engineer and NICDCL is also there. Page 122. That is the valuation made by the Tala on the by the Assam PWD. And whatever the repetitioner submitted, that is page 161. Whatever they demanded on their own, they have submitted it. That is page 161. Page 161 to page 168. So all the documents are with my lord NICDCL, and all the parties can be present on a particular date. And whatever the valuation is required to be done, that will be decided accordingly.
Measurement.
And the section 3F, my lord, specifically provides that land has already vested with the central government, and they can enter the premises and they can construct the house. Section 3F may can be looked into, my lord.
3F of the
3F National Highway Act, my lord.
NHA.
My lord. PF. Section 3F. Right to enter into the land where land has vested in the central government. Where the land has vested in the central government under section 3D, it shall be lawful for any person authorized by the central government in this behalf to enter and do other act necessary upon the land for carrying out the building, maintenance, management, or operation of a national highway or a part thereof or any other work connected therewith. Section 3D notification has already been published. 3D award has been published. Amount has been deposited. They are not satisfied with the amount. They went to arbitrator. My lord, at this stage, my lord, construction, there is a
My learned is very correct, but I'm not on these also. Malad. These are things of merit which will be decided by the arbitrator. Malad, they have already received amount of 58 lakhs. They further demand an amount of 30 more lakh, 30 lakhs. Malad. So,
Just a minute. Just a minute.
Malad.
No point keeping it pending. Writ appeal was disposed of, isn't it?
Disposed of, my lords.
The eighth interim of the arbitration was also vacated.
No, not vacated, my lord. The direction was the evaluation report,
The identity order of the arbitrator.
no, it was not touched, my lords.
No. It was vacated.
Taken care of, my lord.
No,
Any order or for the arbitration stand vacated, vacation.
no, my lord, it will stand vacated after submission of the report.
Evaluation has been given now.
Not given.
Not given, report has not given, only measurement part has been done, my lord.
What about their annexure, which Mr. Chukia was referring?
That is by the Assam PWD, division bench first order by CPWD, that is his appeal.
This report.
CP.
But certain information as, my lord, directed by the last order has still not been provided, my lord. I had a talk with the executive engineer. My lord, he said that when in terms of the earlier order, my lord, within 3 days, certain informations were sought provided, my lord. The dispute is, there is some dispute is still there, which, but his prayer is entirely different. This can go on, but why should the work suffer? My lord, but the ad interim order would remain, my lord, till the valuation report is submitted. We have. What is the ad interim order, arbitrator?
My lord, there, my lord, is page, my lord. At page number 25, my lord.
Eh?
Of the IA.
25 the IA, my lord.
25.
25.
Not the reference.
No, 24. 24 is the restraint order. 24, my lords, the respondents are directed.
Not to demolish,
24, my lord.
not to demolish.
Yes, my lords.
And 25, my lord, is the another order of this, my lord, which has been complied with by the.
No, if the writ appeal was disposed of in September 2023, why don't you complete the formalities?
My lord, there's a problem, my lord. We have done the measurement. Lord, after the measurement, my lord, we have sought for the years of construction of the building from the, my lord, Kala, my lord. And this is the
I
email,
have
my lord.
pointed out, my lord, yeah, page 121, page 122 year of construction is there.
No, give it to them.
My lord, we have.
Lord, we have been constantly
We have already,
emailing.
NIC diesel, my lord, we have handed over it to it. Lord, to be recorded, I have handed over it to the, my lord.
Better, my lord, better to mail
My
it
lord,
to.
NIC diesel, my lord, we have not received any communication from CPWD. We have received communication from the NIC diesel. So I communicated to the NIC diesel, not CPWD.
Mr. Gogol, if it was communicated to you, why didn't you?
Well, we communicated, my lord, then now only they have come with this issue that they have communicated to us. No, my lord, once we received a query from the CPWD, we forwarded it, my lord.
No, Mr. Gogol, the matter.
These has been,
Your prayer, no doubt, is of immense public interest, but we cannot just bypass the orders of this court.
my lord.
Court in September said that you complete the.
My lord will
formalities.
see the.
Until you complete the formality.
Excellent. They too.
Or
My lord,
until
the-
you completion of the formality.
My lord, what has been harping about, my learned senior is harping about a letter of 14/3/24. My lord, this has been all examined, and after examination and scrutiny, my lord, this order was passed, my lord.
Which order?
My lord, this, it is a 14/3, and I'm assailing and I'm on an order of order 14/3,
24.
Day before yesterday.
and this we have received. This is subsequent to filing my application, my lord. This is my order is of 12.
Mr.
My lord,
Gogol,
My order is of 12, my
complete
lord.
the formality.
yes, sir.
My order is of 12.
How soon can you complete the formality?
My lord, 1 week, my lord, 10 days.
And Lordship may direct all the parties to be present on site ballot. I will also be present.
That is subject, my lord. Also, you can make furnished, my lord.
My lord, this report can be furnished to arbitrator. No on-site verification necessary for that, my lord.
The instance I have been filed for modification of the final order dated 28/9/2023, passed in WA 375 of 2023 provide the aforesaid final order, it was provided that the ad interim stay dated 19/4/2023 passed by the learned arbitrator would stand vacated after valuation report is prepared and presented in the arbitration proceedings. Full stop. Para. 3, J. Tutia, learned counsel appearing for the CALA, comma, Department of Revenue, Karbi Anglong, KAAC, has submitted that the assessment has been made and the report prepared. Assessment and valuation. Assessment and valuation has been made and the report prepared, which however, and the same were also forwarded to the NHIDCL. Full stop. 3, Alam, the learned counsel for the writ petition or respondent.
No, I'm not, I'm the respondent about,
In the writ petition. Therefore, the respond number.
1, 2, 3, 4, my lord.
Respond number 1, 2, 3, and 4, however, submits that the report is not complete as certain years have not been given. Full stop. Para. 3, Tutia, the learned counsel for CA and however clarified that even the years have been given, which however.
Years are not mentioned.
Well, they were looking to the papers, my lord. Without looking into the papers, they are making the information.
Sufficient. Years have been given. Full stop. Para.
Look into it.
Para.
Year of construction 2015, NSC signed it. They have to go, you are making the wrong statement.
Furnished. To the
Year of construction is there in 2015.
comma. Let the report be furnished. Let the CPW comma. Let such report be furnished to the CPWD. Full stop. 3, Tukia, the then counsel for the Sala has submitted, has in fact handed over a copy of the report to Sri H. Gupta, learned CGC, appearing for the CPW. Full stop. Para. To facilitate the completion of the report, comma, and as suggested by the learned counsel for the parties, comma, let a final joint verification be done on specific date.
When do you want?
Any day, my lord, but we can use it. I have no problem.
On the valuation report is furnished to the fund.
On this holidays.
No.
No. Can I write it down?
My lord, we have, with due respect, my lord, the joint measurement has been taken. Only the valuation remains, my lord.
We'll give a 1 week time only.
Yes, my lord.
On today's 21st.
On 28th.
Yes.
No, no,
28th.
holidays are-
There'll be some holidays. We'll have it on first.
Yeah.
First of April,
My lord.
2024, wherein all the parties, including the respond number 1, 2, 3, shall be present. Full stop.
On the site.
On the site. Full stop. Let the matter be listed for consideration on 3rd of April. When final orders will be passed on the item.
My lord. All right.
Admission.
Lordship, in this matter, the learned advocate general is appearing. Lordship, he is on legs. Can it be passed over for the time being?
Your Lordship, I'm appearing in this matter in item number 4. Your Lordship, this is a petition whereby we've challenged the constitutional validity of entry 11 schedule 1 of the Court Fees Act, which essentially prescribes a ad valorem court fee of 7%.
Counsel, are you appearing for item number?
4, your Lordships.
No, we are on item 2.
Oh, I'm so sorry, your Lordships.
Yes, two,
Sorry,
is
Lordship,
who's
I-
the- two,
Two.
who's appearing?
My lord. Lord, this is an appeal against the order passed by the learned single judge. My lord, here the respondent herein, my lord, as a writ petitioner, my lord, challenge the order of his dismissal, my lord, because he was dismissed from service on the ground of, my lord, because he has produced the fake, my lord, HSLC certificate. And my lord, the process of inquiry, inquiry proceedings, my lord, had taken place, and consequently, my lord, he was dismissed from service. My lord, the issue before the learned single judge was at page, my lord, 54. Page 54, my lord, paragraph 39 of the impugned judgment. That is the issue, my lord, which was before the learned single judge. May I read, my lord? Issue for consideration in the present case is as to whether submission of false fake educational certificate for securing appointment in CRPF would constitute a misconduct so as to entitle the respondent authority to impose punishment under section 11(1) of the CRPF Act read with rule 27 of the CRPF rules, and as to whether there is any procedural irregularity in the departmental proceedings. So, my lord, this was the issue before the learned single judge. And my lord, the learned single judge held that as the issue relating to fake education certificate is a subject matter prior to his appointment, my lord, section 11 would not be applicable. My lord, that was the finding of the learned single judge, my lord. And my lord, another case, my lord, learned single judge relied on the judgment of Ram Charan versus IG of police to held that, my lord, the termination should have been pursuant to following rule 14 of CCS rules. My lord, that is also perhaps incorrect, my lord, if I may take your lordship to the judgment of Ram Charan versus IG police, my lord, which I have given. My lord, reliance was placed on this judgment only, my lord, in the entire judgment. My lord, in this case, my lord, here also, my lord, the petitioner was constable in CRPF. He was dismissed from service on the ground of production of fake certificate. My lord, will see paragraph 2, the article 1. Lord, in the article of charge in the last paragraph, Lord, the charges were framed under section 11(1) of the CRPF Act read with 1949. And my lord, thereafter the High Court, my lord, dismissed the appeal. And my lord, he went before the Supreme Court. Finally, my lord, the appeal was dismissed, my lord.
Yes.
My lord, the learned single judge was the opinion that, my lord, section 11 would not be applicable.
Yes, madam.
My lord, section 11. My lord, reinstatement is directed, my lord.
Inquiry, my lord. The reinstatement, it is only for the purpose of inquiry is what has been directed. Now, my lord, there are division bench judgments of this honorable court which says that section 11 will not be applicable in such a case, number one. Number two, my lord, if lordship kindly has paragraph 50, my lord, of the judgment, my lord, at page 26. Paragraph 50 of the judgment, my lord. Which part, my lord?
Paragraph 57.
Paragraph 50.
We are not the procedure for which section has been taken into.
Oh, my lord, yes, paragraph 57. Revert back.
That's the issue.
The fact is under
The matter and view of the above discussion.
submission of fake or false education certificate for securing appointment in CRPF would not constitute
Yes.
not constitute a misconduct lawsuit will further, so as to entitle respondent authority to impose punishment under section 11(1). Therefore, even in the other cases also, even in the Thogendas case, if lordship will kindly have paragraph 47. In Thogendas case also, in exactly similar circumstances, this honorable court had directed not 11(1), you do it under the CCS rules. You do it. And even in this case, the inquiry officer had held that the charges are not proved. Thereafter, the disciplinary authority makes his own inquiry once more. Learned single judge has held that that document had to be given to the petitioner before they came to a conclusion. That is all. The procedure irregularity is what has been interfered with. Even if Lordship says 11-1, even then, my lord, it goes back for an inquiry, a complete and proper inquiry, having all the formalities done. And that opportunity has been given to them. Even if it is, Lordship will kindly have the kindly have paragraph 47 for a moment. Paragraph 47.
So what the submission of rules or big certificate, a specific charge on?
Yes.
What a specific charge?
Yes.
So the giving of the document or not document?
Not that document, my lord. What happened is the inquiry officer on the conclusion of the inquiry specifically held that the charge is not proved and may call for a further inquiry. What happens is now with that letter, with that inquiry report, I am not given the further inquiry part. What they do is they write a letter, they don't give me that letter. And they say, for that letter, you are terminated. That is what has been held by the learned single judge to be wrong. But Lordship will kindly appreciate one thing.
But this observation, is not what you are submitting and the observation, because the thread.
That observation is there. That observation is there. Lordship will kindly find.
The submission which you have just made,
Hmm.
that the interference of the cause of effect, that is not part of the recording.
Lordship will find the paragraph 53, it is recorded. It was not on one ground that the writ petition has been allowed and a further inquiry has been directed. The procedural impropriety has only been taken into account, and the learned single judge has time and again said that if it is a fake certificate, you are supposed to go. Procedure has to be maintained. 53. It also transpired that the disciplinary authority had passed the impugned order of dismissal dated so-and-so primarily based on the communication of 25/3/2010 without conducting any further proceedings, which resulted in deprivation of the petitioner an opportunity to defend himself and rebut the said document. Now, if Lordship comes to the penalty, the last paragraph, how it has been dealt with. Lordship will find paragraph 57 a little bit down below, my lord. More so, there is a procedural irregularity in conducting the disciplinary proceeding on the part of the respondent authorities, as the document verification dated so-and-so relied on by the disciplinary authority was not put to notice of the petitioner. Undoubtedly, submission of fake certificate for securing appointment is a grave misconduct. It is made clear that above conclusion of this court under any circumstances is not to be considered that a person who had secured an appointment in service on the basis of fake or false certificate should be allowed to continue in service. It is just that in the opinion of the court, the respondent authorities have recourse to the provisions of inapplicable acts and rules and on procedural irregularity in the department in the present case. Finally, at paragraph 59, they say, however, the respondent authorities are at liberty to take recourse to other applicable provisions of rules and act for taking of action against the petitioner as he is alleged to have secured appointment by furnishing fake or false certificate, which is a grave conduct as may be permissible under the law. No bar has been given to them. So this honorable court under Article 226 will only look into whether the procedure part was followed, whether he was prejudiced by that. If so, they will always have the liberty to redo the entire exercise. I will not have any liberty from this honorable court. But the man should be allowed just to.
Very grave.
My lord, even my lord.
They are reading of the charge, entry into the services. by
My lord,
way of
Lordship will
document.
find the division bench judgment which I have referred to, my lord, I'll give a copy. There the charge was that the man was involved in a murder case. Honorable court held anything can be there. Charge could be anything. Gravity of the offense is another thing.
Don't equate the murder case or rape case with this.
Even
Here you are entering into the services fake documents. There is a judgment of this court division bench.
my lord, no liberty.
India not all India.
Yes, my lord. I have.
You got it.
Yes, yes.
Mohammed Ayub.
Yes, that was referred to. That has been referred to discuss. Now, Lordship, kindly have page 47 for a moment, my lord. Para 47. I'll just.
Initiated into by the single judge. Reversed by the division bench.
Lordship, paragraph 47 for a moment.
And there was no fake document. It was only a misrepresentation in that case. What is the name?
My lord, that is Indian Oil Corporation versus Rajendra D. Halmarkar. My lord.
There's a Supreme Court.
All right.
My lord, here it page 108, my lord. So, my lord, there are basically on two grounds, my lord, the Leonard Singhal is allowed to writ petition. First is that, my lord, Leonard Singhal held that section 11 is not applicable. In my humble submission, my lord, it is very much applicable, my lord, because it is only the provision under which we can dismiss a, my lord, officer below rank, the constable rank, my lord, because, my lord, I will just point out rule 1110 of the CRPF rules, my lord. The contention that CCS rule ought to have been applicable, that is
Oh, that's that. That's all.
my lord,
But
rule
H. Gupta, Leonard Council, Leonard CGC. For the applicants. Admit. R. Majumdar, Leonard Council, interference. On behalf of,
The sole respondent.
behalf of the soldiers. So, we'll have it for hearing. When do you want?
Lordship's convenience. I'm here.
my lord, I am praying also for stay, my lord, because
1 minute.
contempt petition is, my lord, we need it, my lord. After.
After
it-
2 weeks,
it will
after
not-
3 weeks, 3 weeks.
I would not be here on the last week of April, my lord, any other day other than that.
After 4 weeks,
Good to me.
please submit after 4 weeks. In the meantime, come on. Till the next reasonable dates. Parties are directed to mental status quo.
Obliged, my lord.
Item 3 and 4, hearing.
May it please your lordship. This is an old matter of 2018. This has been hard. I have the privilege to appear before 4 honorable chief justices of this bench. My lord, matter was hard at length. My lord, I submitted the written notes on argument, although it was misplaced from the record, and I brought it further. Last occasion on 14th, Honorable Chief Justice fixed the matter for hearing today. This writ petition, my lord, we have challenged the constitutional validity of Article 11 of Schedule 1 of Assam Court Fees Amendment Act 1947, whereby, my lord, a 7% ad valorem court fees has been prescribed for probate or letters of administration or for valuation exceeding
5 crores.
There is no upper limit fixed.
Your lordship, by way of background, I'm appearing in item number 4. It's an identical writ petition filed seeking similar prayers.
How long will it take, AG?
It's a very short matter, but I think, Lordship, my assisting counsel Dipankar is not ready with the case.
See, this is a very temporary bench.
Yes.
If, only for 2 days.
Yes, let it be on a fixed proper bench, Lordship. Otherwise, again, it will get scattered.
You are an assistant counsel.
My lord. My lord, can it be on 4th of April?
Can be.
Your lordship, 4th of April is fine with me as well.
The hearing date. 4th is Thursday.
Yes.
You are Mr.
Pradyumna Sinha.
But Mr. B. Sinha, Leonard Counsel for the petitioners. You are not ready, Advocate General.
Otherwise, I am ready, but my assisting counsel, Lordship, he needs.
So on your request, I'll fix it also.
Yes, Lord.
On request.
On the request of both the sides, Lordship.
Your lordship, we are ready to argue today if your lordship.
Because we also completed our arguments. It's not that we did not complete it. We have also
I
completed.
think it's better
Yes.
before the same bench.
Yes, Lord.
Okay. Also heard Mr.
R. Chaudhary, your lordships.
E. Saikia, Leonard Advocate General Assam. For the respondents. Please the matter for final disposal on 4th of April.
My lord, only one thing, my lord, may I, with your lordship's permission, on the last occasion, submission was made on behalf of Learned Advocate General that Law Ministry is considering to fix the upper limit and they will come with that proposal. But if that is ready, then
the thing is
next date, the time may not be obtained on the same ground.
No, we have not, in fact, what was the happening? There was a direction of this honorable court to the government to look into the matter, and we have considered a committee. On the last occasion, we produced that, the committee has been, they are working on it. Then the honorable court said, we will not wait, we'll decide the matter. That was the understanding.
Yes.
It is not because of that the case is getting pending.
Did not seek time for giving time. to
Mal,
committee.
mal.
In the meantime, committee decides on-
Yes, Mal.
It will be very difficult now because of the election process.
Yes.
It will not be over till.
So we are listing on the fourth.
Yes,
Fourth.
on fourth. Lord.
Mal.
Yes. Highly obliged.
Oblige, your lordships.
जाओ गाड़ी जीती तो जीतेगा.
Your lordships may kindly record my appearance in item number 4, your lordships.
Yes, we pass on this.
Thirty-eight, 39 hearing.
Well, both matters are same. The short point on which appeal is admitted, my lord, is whether the interest as provided under the Bengal Public Demand Recovery Act will be applicable after the matter certificate has been issued by the department.
Mr. Sahiwala, this is just a temporary bench, today and tomorrow.
My lord.
Why not you take it up before the appropriate?
Yes, my lord. I have nothing to say, my lord. I can tell you otherwise.
I'll request by department. When do you want?
Any day, my lord.
Give a date.
In April, my lord. After view vacation, my lord. After view vacation.
Indicate.
Published.
41.
Wait, please, dispense. Look, issue involved in under SURFACE Act, but the petitioner has challenged the jurisdiction. Therefore, my lord, the writ petition has been filed. The respondents has not appeared since long, my lord. They have stopped appearing. May I proceed, my lord? On 20th of March 2019, my lord, interim order was passed. And that interim order was directed to be continued by the order dated 7/6/2023. Interim order, my lord, first at 23/2019.
So you have an interim in your favor.
Yes, my lord. Well, what happened, my lord?
Give them one more chance.
We have taken 3 times. Steps has been taken. They were initially on caveat. They appeared on the first date. Subsequently, they have stopped appearing. Thereafter, we have taken steps. Lordship may kindly peruse, my lord. Last order, my lord, 19/9/2023 for a moment. Service has been complete, my lord. 3 times we have taken steps.
That's why let us, since they put in appearance for respondents 1 to 4. One M Sharma is appearing.
Yes, they have been, but they have stopped appearing, my lord.
I think UCO Bank has merged with PNB.
No, my lord, UCO Bank, they still appear, my lord.
Who's the council? Normally.
My lord, there is just a minute, man.
M Sharma.
M. Sharma is there, man.
Is he aware of this matter?
The caveat was also there, my lord.
Caveat by the bank?
By the bank only. May establish very small matter, my lord, whether the respondents could have acted in the matter, my lord.
Yes.
May I please, your lordship? The engaged counsel, Mr. M. Sharma, is not well today. May kindly adjourn the matter for the time being.
So that means he is appearing.
I'm appearing for bank 1, 2, and 3.
Okay, heard Mr.
T. Chakraborty.
T. Chakraborty, learned counsel for the petition. Para. On request made on behalf of Mr. M. Sharma, learned counsel for the UCO Bank. Then the standing counsel
Yes.
for the UCO Bank. Mr. Metro, when do you want?
Next week.
After 1 week, after 2 weeks.
And thus for respondent number two.
Mr. Endas, then the counsel appears for the respondent number 4.
Ask Mr. Sharma to be here on the last occasion also they were not present.
Yes, Lordship.
There is an adverse report that nobody has entered appearance despite of it.
Yes.
All right.
42.
Well, in this matter, I am for respondent number 7.
Petitioner,
Last rejection was a bit.
Represented. They have challenged the virus of a particular provision. Rule 10
of
of the Village Defense Organization Act.
Who appears for the petitioner?
Mr. Asim Chamua had appeared. Page 21. The writ petition.
But the order which of 13/5/2022 record the prima facie finding in favor of the. It's not the questioning the virus, it's questioning about increasing the rates.
Yes, but
Actually, have you taken any call? These are 2010 rates.
actually that is to be taken by the state respondent.
State response.
We are only.
Mr. Das,
Special order and meeting also took place, madam, that is our affidavit in opposition. Based
have you come to any conclusion? Because
it comes
in
to
13/5/22 order,
100 per day, madam.
no, that what has been recorded is the rates were 60 there 2010 and now more than a decade has passed. We are of the view that considering the critical service rendered by these village defense party, though purely voluntary nature as mentioned, yet warrants relook by the authority. Taking into consideration the minimum wages act.
Well, that, of course, that observation is there, my lord, but the basic bar that is coming on the way is Rule 10. Rule 10 says that it will be a service without any remuneration.
Voluntary.
It will be voluntary. And whatever the otherwise it is considered, I mean, appropriate by the authority hiring them.
Going by strict legal sense, you may be correct. But at the same time, you cannot just ignore.
Yes,
the
that's true.
services rendered.
That is true. That
And
is
what
true.
would be coming is will come in a form of a settlement kind of a.
Yes, yes,
Not-
absolutely.
It's that in spite of the fact that the rules and we say that it's a voluntary service.
You are paying for oil.
I am preparing for Oil India. Our responsibility is actually whatever the state government asks us to pay, we trust,
You are only the paying entity.
yes.
You're just a paying agency, it's the state government here.
Yes, ultimately, the decision has to be taken by the state.
Normally, if they are not present, we could have passed some adverse order. Because division bench, the earlier occasion, seems to have applied mind and said that something is there.
Yes.
I think that
Your lordship may, in that
we
case,
have some opportunity.
Yes.
I mean, that Mr. Das, you can come up with some suggestion.
But, no, cancel it, none appears for the petition. Mr. Endas, then the government.
Please, your lordship.
Yes.
In this matter, item 42, my lord. My senior is legs on court number 26, my lord. In doing a matter.
So what can we do now?
May pass over time. Timing.
This is the last case.
We'll have it on another day with your second time.
On your, on request made on behalf of Mr. J. Kalita,
A Chamua, my lord.
A. Chamma, learned counsel for the petition. List after,
after vacation, my lord, your lordship.
list after 3 weeks.
My lord.
Any date, if your lordship may kindly.
You want a date? Okay, on the, request made on behalf of Mr. A. Chamma, learned counsel.
Date will fix, my lord.
After Bihu.
After Bihu. Sometimes in the month of May, my lord, first week of May.
Second way,
Second May. Second was last 7th May. 7th May, lordship, 7th May,
7th.
7th.
Okay.
In the meantime, the learning government advocate shall take instructions with regard to any development in the matter.
Lordship, our appearance may kindly be recorded.
Yes, Mr.
Yes.
Yes, the senior counsel assisted by Mr.
K. Kalita.
K. Kalita.
For respondent number 7.
Appears for the respondent.
Obliged.
Gently list this matter as it has come on part 2 hearing list as item number 33.
Oh.
And all the proceedings have been completed. Can it be listed on 8th of April 2022?
No. It's a hearing matter, is it?
Yeah,
We'll have it on 23rd.
23rd of April.
Item 1 of daily list, admission.
Your Lordship, Mr. P. Naik appears for this matter, Your Lordship. Lordship, he's prepared, but he's on legs in court 20 right now, Your Lordship. Pass of the matter for time being.
No,
But
no,
in
I'm not passing it over for the timing today.
In the meantime,
Well,
In pass off for the day.
is it the part heard matter?
Your Lordship has heard my part. My part is over
Oh.
and their part remains. And if your Lordships otherwise not inconvenient, my lord, I can just recapitulate the
So
facts.
that you do it on the next day. Today Nayak is not there, there's no
In-
point.
Lord,
On the next day, you recap.
Lordship is not keeping well. also.
But HK does, then I counsel for the petitioner. On request made on behalf of P Nayak, then the standing counsel BTC,
BTC.
list the matter when. Give a short date.
2nd April, my lord.
Second.
2nd April.
It's a hearing day.
Mr. R.K. Talukdar and the
Your Lordship,
standing counsel.
2nd April, Your Lordship, 2nd April will be a little problem, Your Lordship. It will not be there, Your Lordship. Any other 3rd or 4th?
4th April.
Not 4th. Yes, ma'am.
You're not, you're,
I was supposed to go to, I am supposed to go to Kohima in a circuit bench of trial. Even then, my lord, 4th.
I know for the matter 23rd, my senior will be out of state. So can it be fixed from 8 to 12 of April?
8 to
12.
No,
And
that part is the Bihu holidays are coming.
so some from 24th.
25th,
Much.
Lordship for listing it was Lordship.
listing time is over, you mentioned time is over.
Yes, Lordship. Well then, please. Immediate family pension. Immediate for family pension, Lordship. Petitioner son is already expired.
5th April.
Obliged.
2.
My lord, issue regarding, my lord, whether the petitioner who is a professor of Amyo Kumar Das, who will be the age of superannuation. Lordship has already heard the matter on the last occasion. And Lordship may recollect, my lord.
Yes, Miss.
My lord,
Shrutia.
Mr. Dinath is appearing in the matter.
Is it Dinat or TC Shrutia?
Both are there, my lord.
Both of them are there. My lord.
Have you got the cabinet memorandum?
Well, my lord, that is not, I'm not aware of that. Mr. Dinath will be appearing in the matter. Just 2 minutes, my lord.
Okay, I'll wait 2 minutes to
Yes.
run and come.
Yes, my lord.
Till then, my lord, may I just,
No, let's see. if-
Lordship. And even if, my lord, that is not there, but there is
No,
no.
I want to see the.
Lordship,
cabinet
Lordship, that is there, my lord, that is absolutely, it is on the part. Otherwise, my lord, the petitioner, there is no definition, statutory definition of the term educational institute, which excludes research institute from its purview. I have not come across, my lord, any definition, any statutory definition of educational institute. In absence of that, my lord, excluding research institute from the purview of educational institute, in my respectful submission is per se, my lord, not permissible under the law. Because research is a broader sense, my lord. Education is a bigger term which encompasses research also. And And I have also division bench judgment of Kerala High Court. It was placed, my lord, which says, my lord, research is an essential part of education in India. If your lordship otherwise inconvenient, then my lord, the date may also be fixed.
No, let us see what,
Lordship.
at least they've got the office memorandum.
Yes, yes,
The cabinet memorandum.
Lord.
Yes, case.
Open to.
Lordship, in this case, at least as far as Mr. Government Advocate is concerned, your lordship, Mr. T.C. Sutia is doing the case. But your lordship, he is sick today, he has not come. At least a short accommodation also, maybe Monday or something.
Maybe on a hearing day.
Monday is already.
Whichever day, I'm saying the next working day, your lordship. I'm just paying for a short accommodation in this case.
Okay, hurt
On a
Mr.
hearing day, my lord, kindly be fixed.
Hurt Mr. S.
T Chakraborty.
T. Chakravarti, then council. So who is the amicus curiae? Amicus curiae is not.
No, S. Chakraborty was there, but he told that he will be coming. He is coming here on lake. Man.
On request made on behalf of Mr. T.C. Shutia, then it's additional senior government. List the matter. Again on
2nd of April, my lord.
as part of.
Second.
Yes, any information?
My lord, I had called him, but he is not receiving. Maybe he's on legs in another court.
Who?
Mr. D. Nath, my lord.
Miss Shutia is happening.
Yes.
Should be
2nd of April, man. Deeply obliged.
obliged.